Good afternoon to all the aspirants of UPSC. I'm sure you're all now very busy in preparation for your upcoming prelims on 28th of May. And we at RAO'S Academy are going to help you in your preparations for the upcoming examination. We have programmed a test series of topical subjects as well as full-length tests, which are ongoing right now. We have already completed 2 geography tests, paper 1 and 2. And the discussions on the answers are available on YouTube. So please go to the YouTube and you can access the question paper as well as the answer discussion, which will help you in your geography preparation. And today we have started the polity paper, paper 1, and will be followed by paper 2 polity. And this will also and this discussion will be on the first 50 questions of this paper. And it will definitely help you in your conceptual clarity where polity is concerned. So let me introduce myself. I'm Aruna Mohan Rao, 1987 batch IPS. And after a retirement, me and my husband, who is an IAS officer, we both have decided to give back to society, share our experiences and our journey as IAS and IPS officers. We would like to, our main aim is only to mentor, guide, counsel you, and also give you the best possible coaching so that you can clear the exam. And we want more and more students to clear this particular exam. I know it is a tough exam, but it can be made easy with specified, focused guidance and mentoring and counseling. And there are many do's and don'ts. I'm sure you have all gone through the whole process, but experience definitely will count. And then your practice, the way you study, and the whole journey that you undertake in this particular exam, we will be there to help you, guide you, and handhold you throughout this journey. We have at RAO'S Academy, we have curated a lot of programs for you, and we would like you to contact us at our at the numbers that are being scrolled, and also ask for any kind of guidance or doubts, clearance, or anything that you anything related to this exam. We are there to help you. So now on that note, let's start the analysis of the polity paper 1, question number 1 to 50. So I will be giving you brief discussions, a brief explanation of each question so that you understand the basic concept. So the first question, the first question says, consider the following statements. By the States Reorganization Act 1956, the concept of union territory was introduced. I think this is a correct statement. Article 239, Articles 239 to 241 are explaining about the union territories. So your first option is correct. The term UT refers to those territories which are too small to be independent or too different in terms of economy, culture and geography to be merged with the surrounding states, or are financially weak or are politically unstable. This is also a true statement because, as you know, Andaman Nicobar Islands or your Daman, Diu, Lakshadweep, these are all very small units, small islands which have their own economy, which they have their own culture, traditions, and they are extremely culturally rich. So this statement is also correct. UTs are those territories which couldn't survive as separate administrative units and thus required to be administered by the union government. They are too small to be administered by themselves. So it is they have been made as union territories. The word union itself will tell you that they are under the union government. So the option D is your correct option here, as all the 3 statements are correct. So all the above are correct. This is your first question. We go to the second question. Consider the following statements. Just solely means conferring citizenship on the basis of place of birth while jus sanguinis gives recognition to blood ties. So this is the jus soli is by birth, it is a English common law word, and jus sanguinis is a Roman law word. And the Constituent Assembly of India rejected the racial idea of jus sanguinis because it was against the Indian ethos, which is again a correct statement. And the Constituent Assembly of India rejected the racial idea of sanguinis because it was against Indian. And the second point was Motilal Nehru Committee of 1928 was in favor of jus soli, that is by birth. So all the three statements are correct. The option C is the correct answer. So now we go to the next question. Consider the following statements. Indian Constitution has a provision for single citizenship. Is that correct? That is a correct statement. In India, only a person can get citizenship, not a legal entity such as a company or a corporation. This is also a correct statement because citizenship is given to a particular person only. This is a correct statement. The third statement says, no state can provide reservation to its citizen in educational institutions on the basis of place of residence. So this is nowhere in the books. It is nowhere written that no state can provide reservation on the basis of places of residence. As an exception, some states do give it, but it is not a written law. So which of the above statements are not correct? You have to be very careful when you read questions, because suddenly in your anxiety and hurry to write the answers, sometimes you miss out on the correct or not correct, and sometimes you'll have an option which will say that these two are correct, so then you'll just mark the two as correct. The answer here is C. Only 3 is wrong. That is the wrong answer. So that is the way you should be very careful when you read the question. Reading question, take time, try to understand what the examiner is trying to ask you. The next question is, consider the following statements. A limited amending power is a feature of the basic structure doctrine of the Constitution. This is a statement saying the limited amending power is a feature of the basic structure of the Constitution, and the harmony and balance between fundamental rights and directive principles is also a part of the basic structure. So the answer here is that both the statements are correct. Both the statements are correct. In the Minerva Mills case of 1980, the Supreme Court, there was a judgment saying that the Constitution is supreme and not the Parliament, and the two features that were added to the basic structure was, one was judicial review and the second was the balance between fundamental rights and directive principles, and also the limited amending power of the Constitution is also a basic feature. So your option C is the right answer. Then we come to the next question. Article 31B introduced the 9th schedule and stated that any law under it could not be challenged for the violation of fundamental rights as per Article 31(2) of the Constitution, and Article 13C states that the Parliament shall not draft any law which abridges the rights conferred under Part 3, and to that extent it shall be void. So this is related to the first amendment, to the first constitutional amendment which added Article 31B. None of the acts placed in the 9th schedule shall become void on the ground that they have violated the Part 3 of the Constitution. This was basically related to the rights of the rights relating to land and land reforms. So here the answer to this question is C. Both 1 and 2 are correct. Both 1 and 2 statements are correct. Okay. We go to the next question, question number 6. Consider the following statements. The Indian Federation is similar to the US Federation in terms of association of states. Indian Federation is similar to US Federation in terms of association of states, and the states of Indian Union have no right to secede from it. The states of Indian Union have no right to secede from it. So the answer here is the Indian Federation is similar to US Federation in terms of association of states. Is that a right option? No, it is not, because in US has a federal structure, India is a union of states. So this is the wrong statement and this is the correct statement. So your answer will be B, that is option 2 is the correct, So we go to the next question. We go to the next question, which says, only a natural born citizen of India can become the president. Only a natural born citizen of India can be a president, whereas in the US, anyone who is a citizen can become a president. Okay? And while in the US there exists dual federation, Indian federalism at best can be described as cooperative federalism. This, because you know it is true, this is a correct option. Think about this. In India, anyone who is a citizen can become a president, whether he gets his citizenship by birth or by descent or by naturalization or acquisition of territory, whatever it is, he can become a president. There is no, only the condition that you find is that he should be a citizen of India. How he has attained the citizenship is not in question here. But in the US, it is that only a natural born American can become the president of the US. He should also be 35 years of age and he should also lived in the US for 14 years. These are the conditions for the presidentship of USA. So only the answer here is B only. This is the correct answer and this is not the correct option. So this way you have to eliminate the first option and go for the second, which this is the correct answer. Now we go to the next question. I think I skipped one. Yeah. Eighth question. Consider the following statements. Fundamental rights are not sacrosanct or absolute. I think you can mark that as a correct. They are not. Even during national emergencies, all fundamental rights cannot be suspended. All fundamental rights cannot be suspended. Article 20 and 21 will remain. They cannot be suspended. And during military administration, so fundamental rights might be curtailed in any specific location, which is true. If it has any kind of law and order or public order issues, definitely fundamental rights can be curtailed in a particular specific location. So your answer to D will be all of the. So this is the correct statement. This is also a correct statement in the sense that they cannot be suspended, and during military, fundamental rights might be curtailed. Anybody, this is also a correct statement. So all of the above is the right answer. Here, fundamental rights are not sacrosanct because during national emergencies, many of the fundamental rights can be curtailed. During national emergencies, definitely all fundamental rights cannot be suspended. Yes, all cannot be. 20 and 21 will remain in force. And during military operations or administration, any fundamental right may be curtailed in any specific location. So all the three statements are correct. We go to the next question. Regarding procedure of amendment, Article 368 of the Constitution and Article 368, consider the following. A bill for the purpose of amendment can be introduced by both ministers as well as private members of the parliament. Is that true? Think about it. It is a correct statement. The president can use only pocket veto power in case of amendment bills. Can he do that? Can the president do that? The president can, with regard to amendment bills, the president can neither withhold or send it back for reconsideration. He has to give his assent. And every amendment bill should be ratified by the legislature of half of the states by a simple majority. No. Any issue which relates to the federal provisions of the Constitution, only the federal provisions of the Constitution, will need the ratification of states and not all the amendments. So this statement is also wrong. So when you take out your 2 and 3, you are left with 1 only. So your option will be B. The B option is the correct answer to this particular question. Consider the following statements. The Citizenship Act of 1955 describes different methods to acquire Indian citizenship. You have a Citizenship Act that has been amended a number of times, but the original Citizenship Act describes different methods to acquire Indian citizenship. How can you acquire? By birth, by descent, by registration, by acquiring of territory. These are some of the methods in which you acquire citizenship. The Citizenship Act of 55 describes different methods for termination of citizenship. How do you terminate? By you can renunciation, termination for any other reason, acquiring citizenship of any other country. Once you acquire the citizenship of any other country, then you will automatically lose your Indian citizenship. So and then this act also regulates the registration of overseas citizens of Indian cardholders and their rights. Yes, the rights of the OCIs are also incorporated in the Citizenship Act of 1955. So all the above statements are correct. So this is your Citizenship Act of 1955. Then your next question is, consider the following statements. In India, the concept of single citizenship has been adopted. Yes, I live in the state of Madhya Pradesh, but I have only citizenship of, I am an Indian citizen. I do not have citizenship of my particular state. In USA, the concept of dual citizenship has been adopted. Yes, the Indian US citizen is a citizen of the Union as well as the state to which he belongs. Both India and US have federal structure of government. Broadly speaking, India has a cooperative federalism, so India also has a federal system of government. So your options will be, all three are correct. That will be your answer. All three of these statements are correct. Let's go to the next question. Consider the following statements. Article 6 deals with the citizenship of certain persons who have migrated from Pakistan. Yes, this is a correct statement. Okay. Any person who has migrated from Pakistan shall be a citizen of India at the time of the commencement of the Constitution if he or either of his parents or any of his grandparents was born in India as given in the Government of India Act 1935. This is also a correct statement. Any person who has migrated from Pakistan shall be a citizen of India at the time of the commencement of the Constitution if in case such a person has migrated before March 1st, 1947 and has been ordinarily resident in India since his migration. This statement is wrong in the sense that this date, March 1st, 1947 is not correct. The actual date is 19th July 1948. So this statement is wrong. So you come to, the answer is A. 1 and 2 statements are correct. Okay, got it? So now let's go to the next question. Consider the following statements. The state is such a constituent division which has its own elected government and has the powers to frame laws, while a union territory, being a small administrative unit, is ruled by the union government. So here we are talking about the differences between a state and a union territory. So state is a constituent division which it is elected and it also has powers to make its own laws. But the union territories, as discussed before in another question, they are governed by the center. An Indian state and the Union of India have federal relationships, while a union territory has a unitary relationship with the union government. Yes, it is a one-way administration, that the union government under the name of the President of India rule the union territory, while the Indian state and the union, in the states of India and the union, have a bilateral relationship of the union list, the state list and the concurrent list. And also there are many administrative and legislative and other administrative procedures that are divided between the union and the states. The governor is the constitutional head of the state, while the President of India is the executive head of the Union Territory. This is also a very correct statement. Governor is the titular or the constitutional head of a state, while the President of India is the executive head of the territory of a union territory. He administers the union territory through a lieutenant governor or an administrator. So all your three statements are correct. So we have all three statements are correct. So your option A will be your correct answer. We go to the next question. All international treaties and agreements of which India is a part are negotiated and concluded on behalf of the Minister of External Affairs. While a proclamation of national emergency is in operation, no ordinance can be issued on the state subjects. So here the all international treaties and agreements are going to be on the behalf of the President of India. They may be executed by the External Affairs Minister, because he is the person who has live contact with the other countries of friendly countries, but everything will be in the name of the President of India. And while a proclamation of national emergency is in operation, no ordinance can be issued on. So there is a national emergency which is going on. So definitely ordinances can be passed by the central government on the state subjects as well, because but those subjects which are made on those laws which are made on the state subjects, they will cease to be operative 6 months after the emergency is over. So here both the statements are wrong, but here the question asked is which of the statements are correct. So both the statements are wrong. So your answer should be D. Both the statements are wrong. We go to the next question. With reference to Constitution of India, consider the following. The ideals of social and economic justice have been borrowed from the Soviet Constitution. As you know, the Indian Constitution has borrowed a lot of features from the best, and they have taken the best practices from many constitutions of the world. And yes, social and economic justice have definitely been taken from the Soviet Union. The concepts of liberty and equality in the preamble have been taken from the French Revolution. That is also correct. The legislative procedures enshrined in the Indian Constitution have been borrowed from the Government of India Act 1935. This is not correct. They have been mostly adopted from the British Constitution and British procedures. So here your answer will be, what will your answer be? It will be 1 and 2 are correct. So your answer will be C. Okay, that will be your correct answer. Consider the following statements about the preamble. Preamble is very important because there are so many. It is like a front. It is like a prologue, or it's like a introduction to the whole constitution, and it embodies all the concepts that will follow in the constitution, and it is like a introduction, it is like a forward. So the preamble, these are the questions. It is based on the objectives resolution moved by Pandit Nehru. Yes, definitely correct. It stipulates January 26, 1950 as the date for adoption of the constitution. This is wrong. It is November 26, 1949. And not January 26, 1950. That was the day when the constitution was actually adopted. And it states that it derives authority from the parliament. No, it derives its authority from the people of the country. From the people of the country and not from the parliament. So your option here is, which of the statements given above is correct? So there is only one which is correct, that is your option A. So option A is your correct answer to this question. We move on to the next. The drafting of the Indian Constitution was done by the Constituent Assembly. In this regard, consider the following statements. You know that a Constituent Assembly was the one which drafted our Constitution over a period of time. The assembly was elected by universal adult franchise. Universal adult franchise is where all people who are eligible to vote will vote for the candidates. The assembly was, but at that particular time, adult franchise, universal adult franchise was not in vogue, so this statement is not correct. The assembly was dominated by members of the members of the Indian National Congress. Yes, that is a true statement, because the Indian National Congress was leading the independence of freedom movement in India. The assembly worked in a systematic, open and consensus based manner. Yes, it worked in a very systematic manner. That is why in a very short time they came up with such a huge document which is still very vibrant and alive. So here you have the option of having which of the above statements are not correct. He says not correct. So again I said be very careful when you read the answers. There are two correct answers but one is wrong. So A is your correct option. Only one is wrong. They were not elected by a universal adult franchise, but by mostly by the elected members of the provincial assemblies. So now we go to the next question. In India, the right to form cooperative societies is a. What is the right to form a cooperative society? It is a fundamental right. By the 97th constitutional amendment, this was made a fundamental right under Article 19. Okay. Cooperative societies you can form under Article 19, which was introduced by the 97th Amendment Act, and it is a fundamental right. Consider the statements given below. The 19th question is, First Amendment Act empowered the state to make special provisions for the advancement of socially and economically backward classes. Yes, that was the first amendment which was done to the Indian Constitution, and this was included in the First Amendment in 1951. The First Amendment Act provided the saving of laws providing for the acquisition of estates. When we got independent, there were a lot of issues relating to right to property, and also to issues relating to land reform, privy purses, and many other issues relating to the land. So the First Amendment made the saving of laws providing for the acquisition of estates, and by this act the 9th schedule was added to the Constitution. This schedule protected land reforms and other laws, included it from judicial review. This is also a correct statement, because 9th schedule made it to protect the land reforms. The 9th schedule was also added that any laws made in this connection will not be subject to judicial review. So here all your options are correct. So your option will be D. That is your correct answer. We go to the next question. Regarding proclamation of national emergency in India, consider the following. The occurrence of an actual armed rebellion is always required in order to proclaim national emergency by the president. Please read the statement carefully. It says the occurrence of an actual armed rebellion is always required in order to proclaim national emergency by the president. A written recommendation from the cabinet is a prerequisite for the declaration of an emergency. It's a prerequisite for the declaration of an emergency, and the constitutionality of such a proclamation can never be questioned in a court of law. These are the three statements that have been given. So occurrence of an actual armed rebellion, there is no need that there should be an actual armed rebellion. Even the impending or the there is an intelligence input saying that there is going to be an armed rebellion, even then the president can promulgate the national emergency. So this statement is wrong. A written recommendation from the cabinet is a prerequisite. Yes, otherwise it will be very arbitrary. So it has to come from the cabinet in a written form. And the constitutionality of such a proclamation can never be questioned in a court of law. Yes, before it was immune from judicial review, but the 44th Amendment Act of 1978, 44th Amendment of 1978, this made it, it put this also under the purview of judicial review, and it could be questioned in a court of law. So here the questions are, which of the following statements are correct? Here the statement is only 2. So your option is A. There is no need for an actual occurrence. Even the impending occurrence of a armed rebellion can is enough for a national emergency to be proclaimed. Written recommendation zaruri hai, and then a constitutionality of proclamation can now be admitted in a court of law. 21, the question number 21 is, provisions of the constitution that can be amended by special majority of in parliament and consent of half the legislatures are: manner of election of president, article 368 itself; salaries, allowances of president, vice president, judges, etc., Supreme Court and High Court. What are the provisions which need a special majority? So one is, yes, manner of president election. Then you have, in addition to this, you have many executive power of union and states, Supreme Court and High Courts, representation of states in the parliament. All these require a special majority of the in the parliament. So here the option here is B. This is correct, and this is correct. These all need special majority of parliament to be amended. Okay. So your answer is B. Salaries of president, vice president, they cannot be diminished or to their disadvantage when they are in office. So this is your C option. Which of the following is correct about the right to education? Right to education, very much in the news because of so many developments in that field. So what is right about the right to education? It is provided in Article 21A. Okay, it is provided in Article 21A. Is that right? It is provided by the 86th Constitutional Amendment. That is also correct. It is provided for children between ages of 6 and 18. This is a wrong statement. It is from 6 to 14. 6 to 14 years of age children have the, it is compulsory for the government to ensure that they all go to school. So it is the right to education brought into the constitution by the 86th Constitutional Amendment and insertion of Article 21A. So your answer will be 1 and 2 only. A will be your option. (23) A provision in the Indian Constitution brought from the British Constitution includes first past the post polling system. Yes, India. Anybody who gets a 50% margin majority will be winning an election. Parliamentary form of government, judicial review and emergency provisions. These are the options that you get. Judicial review we have got from the US, emergency provisions we have got from Germany. So parliamentary form of government and first past the post systems have been adopted by from the British government. So here your option will be C. The C will be the correct answer. Judicial review we have got from the USA and emergency provisions we have got from the German government, German constitution. The maximum number of times a person can be president of India. It has not been specified in the constitution. So it is assumed that a person can, Article 57 says that he can be a president any number of times. Article 57. Any number of times a president can be re-elected to the post of president in India. Provisions of the constitution that can be amended by simple majority. Provisions, we have done provisions which need a special majority. Now we are doing provisions which can be done by amended by a simple majority. So here the options are, you have the option of formation of a new state. Formation of a new state requires a simple majority of parliament. Creation and abolition of legislative council and creation of council of ministers for union territories. Union territories the number of ministers that have to be there, that will also be done by a simple majority of the parliament. So here the option is, your option is C. All these particular statements are new state, yes, simple majority passed. When they get a creation abolition of legislative council, whether it should be there or not, when they get a proposal from the state legislature, creation of council of ministers for union territories also by simple majority. So your answer is C. We go to the next question, 26. With reference to the constitutional amendment bill, consider the following statements. A constitutional amendment bill can be introduced in any house of parliament or a state legislature. So here there is a catch. It can be introduced in only the parliament and not in the state legislature. Not in the state legislature, only in the parliament. So this statement is wrong. The ordinance making power of the president can be used to amend the constitution. No, the constitution, the ordinance making power of the president only is limited to making ordinances when the parliament is not in session. A constitution amendment bill can be introduced both as a government bill or a private member bill. Government bill by a cabinet minister or as a private member bill. And this is a correct statement. Prior recommendation of president is needed in introducing a constitution amendment bill. No, it doesn't need the recommendation. Prior recommendation is not needed for introduction of a amendment bill. So your option, all your three, they asked what statements are correct. So your three statements are wrong. You have only one statement which is correct, which is B. So option B will be your correct answer. So let's go to the next. With reference to the Constitution of India, consider the following statements. An amendment to the Constitution of India can be called into question by the high courts. By the high courts in India. As a court of record, the High Court in India has been specially confirmed with the power of review by the Constitution of India. So here your option, an amendment to the Constitution can be called into question by high courts. Yes, this can be done. The high courts also have the power of judicial review. But as a court of record, this is only the power of the Supreme Court given in the Constitution. So this statement is wrong. So your option will be A. This is only the correct statement. Which of the following are likely consequences when a financial emergency is declared? When a financial emergency is declared. The reservation of all money bills for the consideration of the president after they are passed by the legislature of a state. All money bills, because there is a financial emergency, so financial propriety has to be adopted by not only the center but also the states. So all the bills, money bills which are passed by the state legislatures are also sent for the ratification of the president. Reduction of salaries and allowances of judges of the Supreme Court will also be done during a financial emergency, because under no other circumstances can the salaries of the judges of the Supreme Court and High Court be reduced. Reduction of salary or allowances of the judges of the High Court. Yes, this can also be done during a financial emergency because the finances are in dire strait and things need to be pulled up. So that is the all three statements are correct, and so your option A is the correct answer. All three statements regarding financial emergency are correct. Which of the following are envisaged in the Constitution of India regarding the protection in respect of conviction of offences? When you are convicted of any offence, what are the protections that the Constitution is going to give you? Protection against arbitrary and excessive punishment. Yes, you cannot be given a punishment which is more than what is prescribed in the law. So whatever punishment is prescribed in the law for that particular offence, that is the amount of punishment that you can be given by the court. So the first statement is correct. Now the second statement says that protection to persons who are arrested or detained. Protection to persons who are arrested or detained, this is not given, then protection against, let me just go through this, protection against double jeopardy, that a person cannot be given punishment for the same offense twice. He has to be given punishment for one offense only once. If he has committed a second offense, that will be another punishment, but for one offense he can be given punishment only once. That is there should be no double jeopardy. And protection against self incrimination, he can be he cannot be forced to be a witness against himself. Nobody can force you to say something against yourself. You cannot compel him to be a witness against himself. So these three statements are absolutely correct regarding the constitutional provisions for conviction, and this is not for the person who is arrested or detained. There is no protection in the particular conviction of offences, section 20, article 20. This is regarding particular question is regarding article 20, which says that 1, 3 and 4. So where are your option 1, 3 and 4? In C. So this will be your correct option, that will be a correct answer. Consider the following statement regarding directive principles of state policy. Again, a very important topic regarding the constitution, fundamental rights and also directive principles. Many questions have been asked in the previous questions, previous years. So be thorough with what are the directive principles of state policy and what is their constitutional position. So they can be implemented by various laws made to that effect. As they are not justiciable and you cannot go to the court if your directive principles have been violated. So how are the directive principles actually implemented on the ground? They are implemented through various acts like Minimum Wages Act, then a Maternity Benefits Act, Legal Services Authority Act, the many laws relating to children, that they should not be put in hazardous work. So there are many laws which have been evolved over time to bring directive principles into actual effect on the field and being implemented for the people. So they can be implemented by various laws. So various laws have already been implemented in India. They take precedence when in conflict with fundamental rights. Is that a right statement? No, they do not take precedence. It's always the fundamental rights, the basic human rights of a human being, of a citizen, which will always take precedence over your fundamental or over your directive principles. And Constitution classifies directive principles into three categories: socialistic, Gandhian and liberal intellectual principles. So here it does not define, it has been for a convenience of study, people have defined them into different categories, but otherwise they are all put in one bracket. So here your which of the following statements is correct? So you will have to go with only question option A. 1 is the correct option. So that will be your A, will be your answer. Next, which of the following provisions of the Constitution of India have a bearing on health? Health related, what are the provisions having a bearing on health? So we have directive principles of state policy as one option, fundamental rights as another option, 5th schedule, 6th schedule, 11th and 12th schedule. So here you will be answering the directive principles of state policy. Yes, they definitely have a relation to health, where children are not allowed to go into hazardous work. There are many other directive principles which are related to seeing that people live a happy and healthy life. Fundamental rights, definitely most of the fundamental rights will ensure that you have good health, like your right to life, you can profess any trade, profession, occupation, and many other rights. In directive principles, you have children as workers, children to develop in a healthy manner, the state to raise the level of nutrition, and many more. 5th schedule relates to tribals, so it does not have any bearing on health. And then your 6th schedule, district councils of tribal areas of the northeast. These these district councils also have, they are administrative units of these tribal areas, so they definitely have a role to play in the health of the those particular people whom they are administering. And then you have the 11th schedule, which is the rural bodies like the panchayats, which have to maintain good health, hygiene, sanitation, sewage, water, good water, drinking water, so many things related to good health. And the 12th schedule is the urban bodies, which again are related to health in a major way, in providing good sanitation, drainage system, water, and so many other health related issues. So this is also included. So here you have only the 5th option 3, which is not health related. So you have 1, 2, 3 and 4, 1, 2, 4 and 5. So you have an option of the C. C will be your correct answer for this particular question. The next question is, consider the following regarding administration of union territories. Union territories, their relationship with the center is unitary and not federal in nature. As we said before, yes, it is definitely unitary in, it is a one way, it is administered by the central government. Their executive head is an agent of the President of India. Yes, union territories are administered in the name of the President of India through his through his agent. Parliament can make laws on any subject of the 3 lists in relation to the UTs. So yes, it is unitary. He is an agent of the President, and definitely the Parliament can make any laws relating to the union territories from all the 3 lists. So your option D will be the correct answer. Which of the following are classified under the right to freedom of religion? Important for your UPSC. So here, prohibition of discrimination on grounds of religion, freedom of conscience and profession of religion, protection of minority cultures, and freedom to manage religious institutions and affairs. What are incorporated in right to freedom of religion and what are not, or what are the other provisions related to religion in other rights or other directive principles of state policy? So you have article 25 to 28 related to freedom of religion. So 25 says freedom of conscience to profess and practice and propagate any religion. 26 says you can manage on religious affairs. 27 says freedom from payment of taxes for the promotion of any particular religion. 28 says freedom from attendance or to any, you cannot force somebody to attend a religious congregation or instruction. So the first option is article 15. Article 15 says no discrimination on ground of religion. So here this is article 15. Okay, that's article 15. And you also have protection of interests of minorities. This is article 29. So you have 2 and you have 4, which come under the right to freedom of religion. So your answer will be C. Your option will be C. Your next question. Consider the following statement. Indian Constitution is known for its federal structure. In a federation, there are 2 distinct levels of government. One government for the whole country, union or central, and the other for each unit called the state government. The term federal state has been mentioned in part 1 of the Constitution. So yes, we have 2 distinct levels of government. We have the central government at the center and we have the state governments at the states, which work independently in many issues and also work in tandem with each other regarding other issues. The term federal state has never been mentioned in our Constitution, and we have a union of states. We do not have a federal state. Federal state is nowhere mentioned. We have a union of states. Which amendment act made it necessary that at least 2/3 of the members of a party have to be in favor of a merger for it to have validity? Yes, important. This was the 91st amendment of 2003. This was one part, the 2/3 of the members, if they leave, then there will be no anti-defection law over them. and also that 15% of the members of a party or the ruling party, only 15% can become ministers or can hold ministerial posts, and minimum number of ministers should be 12. This was also prescribed in the 91st amendment. Next, consider the following statements which are true. Social, economic and political justices are three types of justices mentioned in the preamble. The purpose of inclusion of the directive principle of state policies in the constitution was to provide social and economic justice to the people. The preamble has not mentioned any type of liberties. The preamble has not mentioned any type of liberties. It has mentioned liberties. So, your correct answer to this will be C. This is not correct. Okay, 1 and 2 statements are correct. Preamble mein liberties ka there is a mention of liberties. Match the following. Match the following. The fourth, this is the amendment and these are the provisions. Fourth amendment says extended the scope of Article 31A, the saving of laws. Amendment 7th, 2nd and 7th schedules were amended. 9th amendment says cession of Berubari Union to Pakistan. And 10th, Dadar Nagar Haveli acquired from Portuguese. So here they are all correctly matched. So your option will be A, 1, 2, 3 and 4. This is your, these are the correct amendments and the correct provisions of that particular amendment. Next, 24th Amendment Act of 1971 affirmed that the Parliament can amend any part of the Constitution including fundamental rights by amending Article 13 and 368. The second statement says 31st Amendment Act increased the seats of Lok Sabha from 525 to 545. And the third statement says 35th Amendment Act gave Sikkim the status of a full-fledged state. So here 24th Amendment, yes, it affirmed that the Parliament can amend any part of the Constitution including fundamental rights by amending Article 31 and 368 of the Constitution, and 31st Amendment Act increased the seats of Lok Sabha from 525 to 545. 35th Amendment Act gave Sikkim the status of full-fledged state. This is a wrong statement in the sense that 35th Amendment, Sikkim was made an associate state of the Indian Union, and 36th Amendment, Sikkim was made a full-fledged state. So this is wrong. So your options will be 1 and 2. Your option will be A. The answer to 38 will be option A. Next question. Which of the following parts of the Constitution are justiciable in nature? Justiciable in the sense that you can go to the court if any of these are violated. Preamble, fundamental rights, fundamental duties, directive principles of state policy. Simple question, simple answer, only fundamental rights. So your option D is the correct option. Only when your fundamental rights are violated can you go to the court. Preamble, fundamental duties and directive principles are not justiciable in nature. Okay. Consider the following pairs. Article 17, abolition of untouchability. Article 19, right to life and personal liberty. Article 21A, right to elementary education. Article 32, right to move high courts directly for the enforcement of fundamental rights. So the answer to this is which are correctly matched. So here only 1 and 3 are correctly matched. Okay. Your Article 17 says abolition of untouchability. Article 19 is your 6 liberties, your 6 freedoms, only 6 freedoms. Okay. And Article 32 is the power of the Supreme Court for the right to move the Supreme Court directly for enforcement of fundamental rights. If you move the high courts, it is Article 226. So this statement is wrong and also this is wrong. Right? You have the 6 rights, your Article 19, speech and expression, to move freely, to engage in any occupation or business, to assemble peacefully without arms. So Article 21 is life and personal liberty. Article 21 is life and personal liberty. 21A is elementary education. So your option will be 1 and 3. So option will be A. Option A will be your correct answer. The right, fundamental right in the Constitution ensures, when you have your fundamental rights, what does it ensure for you? Individual liberty, socialist state, independent judiciary, welfare state. When you have your in fundamental right, what does it ensure for you? It ensures only individual liberty. All the rights that are given to you will ensure that you will be having your individual liberty. It does not ensure that there will be a socialist state, or there will be an independent judiciary, or there will be a welfare state. This is for the government to decide what to do. So here the answer will be B. That will be your individual liberty only. Which of the following enjoy an exception to rule of equality before the law under Article 14 of the Constitution? Members of state legislatures, Article 31C of the Indian Constitution, members of panchayats and foreign diplomats. Who will enjoy a rule of exception? These are the, what are the exceptions to the rule? So in respect, members of state legislatures, they, in respect of whatever they have said or any vote they have given in the house or in any committee, this is not liable to be scrutinized. So they have that exception. Article 31C, it cannot be challenged for violation of Article 14, as I have already told you. Members of panchayats, they will not have this immunity. Foreign diplomats will definitely have this immunity, in the sense that it depends on the diplomatic relations that we have with that particular country. So the options here will be 1, 2 and 4. So 1, 2 and 4 is B. So that will be your correct option. That's the way you have to choose your answers. 43. A constitution can be considered as a body of basic laws of the land. Yes, it will be definitely the basic laws of the land. It may be written or unwritten. India has a written constitution. Many countries do not have a written constitution. Its effectiveness depends upon the mode of propagation, promulgation, its provisions, and balanced institutional design. You may have a very good written document, but if it is not implemented properly, then it will not be of any use to the people of the country. So all three of these statements are absolutely correct, and the answer will be D. The next question, the basic structure, again a very important topic. The basic structure refers to those essential characteristics of the constitution which are considered as vital to its very existence. The parliament cannot amend or take away them even by a constitutional amendment. The basic structure theory. The term basic structure has been mentioned in the preamble. No, it has not been mentioned in the preamble. The basic structure, yes, essential characteristics of the constitution which cannot be amended. They are very vital to the existence of that very constitution. And the parliament cannot amend or take away them even by a constitutional amendment. We have so many amendments and so many Supreme Court judgments which have said that the basic structure of the constitution has to be maintained at any cost. So both these statements are correct. So you have an option of having the answer as A. A will be answer. 1 and 2 are correct. Basic structure has nowhere been mentioned in the preamble. Next question is, consider the following statements. The concept of basic structure has evolved from the issue of the right to property. Right from the beginning, you take the Berubari case, then you take Kesavananda Bharati, you take and all the other cases that have followed. So the basic structure has come somewhere from the concept of the right to property. The first constitutional amendment bill of 1951 is also known as the basis of evolution of the basic structure doctrine. It is the basic structure doctrine. The first Constitutional Amendment Act of 51 was challenged in the Shankari Prasad versus Union of India. Yes, that is also true. So all the All the statements above given above are correct. Okay. The next one, match the following. Union Powers Committee, Nehru. Provincial Constitution Committee, Vallabhbhai Patel. Fundamental Rights Subcommittee, J.B. Kriplani. Steering Committee, Rajendra Prasad. So here you have matched the following. 46th question, and the answer to this is C. All are correctly matched. Union Power Commission, Nehru ji. Provincial Constitution, Vallabhbhai Patel. Fundamental Rights, Kriplani, and Steering Committee, Rajendra Prasad. You also had the Drafting Committee with B.R. Ambedkar and so many other committees which worked in tandem with the within the Constituent Assembly. So the answer to this question will be 46 will be C. Okay, we come to the next one. Consider the following statements which are correct. The objective resolution proposed by Jawaharlal Nehru on 13 December 46 became the preamble of the Indian Constitution. Okay. The preamble has been amended once so far. The preamble of the Constitution has been borrowed from the US Constitution, but its language has been borrowed from the Australian Constitution. This has also been mentioned, so this is correct. The preamble has been amended once by the 42nd Amendment. 42nd Amendment of 1978. Okay. In this, 3 new words were added: socialist, secular, and integrity. Socialist, secular, and integrity. These 3 words were added in the preamble by the 42nd Amendment. Right? So your options will be all of the above. All of the above will be your option. Next, with reference to minorities under the Indian Constitution, consider the following statements. Article 29 of the Constitution deals with religious minorities only. Article 29. Both religious and linguistic minorities have a right to establish and administer educational institutions of their choice. Both religious and linguistic minorities have a right to establish and administer education institutions of their choice. Linguistic minorities are determined on a state-wise basis. This particular Article 29, it says that any citizen having a distinct language, culture, script, they have the right to conserve their own culture. So here it is any citizen and not only a religious minority. It can be a religious minority, it can be a linguistic minority, it can be any other minority. So any citizen can do that. Article 29 has both religious and linguistic minorities, and Article 30 also has it is confined to religious and linguistic minorities and not to all citizens. Linguistic and religious minorities can conserve their own culture, script, and language. So here we have 2 and 3 as the correct option. So you will be going for the option D. 2 and 3 statements are correct. Which of the fundamental rights are available to both Indian citizens and foreigners? There are a few rights which only Indian citizens have, and there are a few rights which both Indian citizens and foreigners will share. So, freedom of speech and expression, equality of opportunity in public employment, right to elementary education. These are the 3 options that you have. So here you have to be very careful in understanding that what are the rights that the Indians or citizens have, what are the rights that both Indian citizens and foreigners have, and what are the rights which only foreigners have. So here you have right to elementary education is the only one which is available to both Indian citizens and to the foreigners. Article 14, 20, 21, 21A, 22, 23, 24, 25, 26, 27, 28, they are available to everyone. And and also 15, 16, 19, 29 and 30, these are only given to Indian citizens. So this is the only right which is given to both foreigners. In this particular options of 3, you have only the third one which is the answer. So B only is the answer. Consider the following statements with reference to emergency provisions. The proclamation of financial emergency remains in operation only for 6 months. No, it is indefinite. It depends on the position of the finances in the country. It can be indefinite. It can be less than 6 months, it can be more than 6 months, or it can be in operation till the financial situation improves. All types of emergency proclaimed by the president have to be approved by the parliament. Yes, they have to be approved by the parliament within a stipulated time. For national emergency, it is 1 month, and for financial emergency and president's rule, it is 2 months. In case of national emergency, parliament approval must be given within 2 months from the date of the proclamation. So this is proclamation of final remains only in operation for 6 months. All types of emergency proclaimed by the president has to be approved by the parliament. In case of national emergency, parliamentary approval must be given within 2 months from the date of proclamation. Which of the following statements is incorrect? This is what you have to be very careful about. So when I wrote 1 and 3, it means that we are talking about this statement is correct, not 6 months, it is indefinite. And in case of national emergency, this is 1 month. So this is also a wrong statement. This is only the correct statement. So which of the following statements is incorrect? So your answer should be A. 1 and 3 are incorrect. Your answer to option 2 is correct. So these are the 50 questions that we have dealt with today. This is our paper 1 of Polity, and we will be coming up with the next 50 to 100 questions tomorrow. So please log on to our channel. We have our YouTube and also our Telegram and Instagram channels, so and our Facebook page at RAO'S Academy. So we also have daily news updates covering most of the news of a particular day. All the important current affairs are covered in that, which is also uploaded on YouTube every day. So you can access that too, to keep yourself abreast of all the current affairs that are going on. And also we will be holding many courses which will be very useful for you. There will be a Gati crash course for the prelims 2023, and if you want to join in, please do call us on the numbers that are being shown on your screen, and we will help you out. So thank you for watching. Have a good day, all of you.